If you are a parent and have a custody or placement issue before the courts, whether it is a new divorce or paternity action or a petition for revision, you need to have a custody and placement agreement written, signed by both parties, and filed with the courts. You can do this yourselves, with attorneys, or through mediation. The purpose of this video is to explain the process of mediation to you. If you do not have a custody placement agreement written, signed, and filed, the courts must order you to mediation. Before we go any further, it is important to understand your rights and responsibilities according to Wisconsin law. Custody is who has the right and responsibility to make major decisions concerning the child under the age of 18. These decisions are the right to marry, the right to enter the military, permission to obtain a driver's license, authorization for non-emergency health care, and choice of school and religion. With joint custody, both parents will make the decisions together. With sole custody, one parent will make the decisions. Where the child lives is not a custody decision. Placement is where the child is when. When your child is with you, you have the right and responsibility to make routine daily decisions for your child. What are those? Basically, anything that is not one of the 5 custody decisions. The law says that each parent will have significant and meaningful periods of placement that maximize the available time with the child. You will each have periods of placement. You need to decide what will be practical for your family and what will address your concerns. So what are the differences between mediating your agreement and going to court?
Mediation is cooperative.
Litigation is competitive.
Mediation encourages disclosure and communication between parties and mutual problem solving.
Litigation encourages deception and discourages communication between the parties and is about self-enhancement.
Mediation builds on parental strengths.
Litigation builds on parental inadequacies.
Mediation addresses the needs of parties.
Litigation addresses the positions of the parties.
Mediation is about future orientation and empathy.
Litigation is about past orientation and intimidation.
Mediation is self-imposed. You maintain control and have creative alternatives while maximizing exploration of options.
Litigation is other imposed. You have no control and have win-lose judgments and limited options.
Mediation is private, confidential, with a cost of $125 each total.
Litigation is in open public court at a cost of the GAL $350 apiece plus $50 a month until the balance of hourly fees are paid in full due at the end. The home study, a $900 total, $450 each, flat fee, plus attorney fees, expert witness fees, child care, time lost work, and the emotional cost and the cost to your children. So what is mediation? It's a process where you sit down with an impartial party and work out an agreement. The purpose of mediation is to write up the agreement that you want and file it with the courts for you. The mediator's goal is to keep you out of court because that's better for your children. The cost of mediation is a $125 flat fee per person, regardless of how often you meet. How long mediation takes depends on you and your issues. Only the parties attend mediation. The mediator does not make any decisions. The parties have total control over what goes into the agreement. What will the mediator actually do in mediation? The mediator may come up with other solutions that might address your concerns, creative ideas. The mediator may offer a reality check, what may happen in and out of court. And the mediator may offer ideas based on research or experience that represent the children's point of view. Once you've been ordered to mediation, your mediator will send you a letter scheduling your appointment at the Walworth County Judicial Center in rooms 2041 or 2044 on a weekday between 8 a.m. and 5 p.m. At your meeting, your mediator will, first, make sure your contact information is accurate. It is your responsibility to keep this information updated directly with the mediator and with the courts. Secondly, the mediator will review this information from the consent to mediate form. The $100 fine for missed mediation appointments. If there's been a history of domestic violence or battery, notify the mediator. There are accommodations that can be made to make sure that everyone is safe and comfortable and that the agreement is valid. The first meeting satisfies your order. After that meeting, mediation is voluntary, but remember, if you make an appointment, you must attend. The mediator cannot give you legal advice or act as a judge. Everything that happens in mediation is confidential. Although the mediator may suggest language, it is up to the parties to decide if it will work for their situation. Neither your attorneys nor anyone else are included in mediation. However, attorneys will receive copies of the agreement when you have settled on what you want. You will never be forced to sign any agreement. If something is important, you must tell the mediator. The mediator is not doing an investigation or a home study. If you have other legal issues that affect this agreement, for example, a no-contact order, you must address them separately. The mediator cannot do this for you. And lastly, a mediated agreement has the same weight as one imposed by the judge. It is an order of the court. Next, the mediator will ask you to take turns explaining your concerns or worries, those things that you want to make sure are addressed in this agreement. Then the mediator will begin drafting the agreement, asking you where you are on various issues, offering sample language, and composing the first draft. The mediator will print a copy of the first draft for each party and arrange for the next appointment if necessary. Should your agreement be completed in that meeting, that is, you settled everything and have a final agreement, you are not forced to sign in that meeting. The mediator cannot forbid you to sign, but will encourage you to take it home and think about it before signing. There are three possible outcomes in mediation: a complete agreement, a partial agreement, and no agreement. A complete agreement: the mediator writes the agreement, the parties sign it, the mediator files it, and it's done. In a partial agreement, you agree to some things, but have some issues you could not settle. The mediator writes up what you have agreed to and lists the disputed items in a cover letter. You sign the partial agreement, the mediator files it, and the state comes in only for the disputed items listed. You keep everything that you did agree to. There is a vast difference between a partial agreement and no agreement. You agree on nothing. The mediator notifies the courts immediately that mediation is terminated, and the state comes in for everything because you agreed to nothing. The general rule is that anything you agree to you keep control of, and anything that you do not, the state takes over. The judges will tell you that anything you can agree to is better than nothing. This is what happens for anything on which you cannot agree. The guardian ad litem is an attorney appointed for your children. Each party pays a down payment of $350. You will also pay $50 each month until the end of the action. At the end of the trial, you will receive a bill for the remainder of the hourly fees that are due. Because of the hourly fees, the cost of the GAL is variable depending on how much they need to do. There is also a home study. This is a flat fee of $900, $450 for each party. The GAL and the custody placement evaluator will interview each party, the children, observe interactions. They may interview others, visit homes, do whatever that they feel they need to come up with a decision about what should be done with anything that you could not decide yourselves. Then you have your court date. You will each put on your case. The judge will discount everything you and those you have to testify on your behalf have to say. The judge believes that you and your witnesses are biased, and of course you are. But the people he believes are not biased are the GAL and the custody placement evaluator. After they testify, the judge will decide what will happen with the disputed items. The judge does not have to agree with anyone else in the courtroom, and you have no say in what the decision is. The last chance to keep control over your family is in mediation. The way you solve these issues now will set the pattern for the way you resolve issues in the future. If you look to the courts to make decisions for you, you will probably continue to do so. If you make decisions by compromise, together, you will probably continue to do that. Remember that no one can be whoever you are to your child. You are the only parents this child will ever have, not just for 18 years, but for life. We look forward to helping you work out an agreement for your family.
As you can see, if mediation is unsuccessful, there are many costs involved, not the least of which is the emotional one. Therefore, please take full advantage of this mediation opportunity, and good luck.